So good afternoon, everybody. I'm Nicola Caiazzo, and today with my colleague Eric Chen, the attorney Eric Chen, we're going to introduce you, as Vivi said, the topic of today's seminar, that is the first Chinese civil code. So please, let's go to the next slide. First, I would like to give you a brief introduction of our firm. Wanjing and JH Law Firm was founded in 2008 and is one of the private partnership law firm approved by China Ministry of Justice. Our firm headquarters is located in Guangzhou, in Jiujiang Town, and is composed by more than 100 professionals, including 9 equity partners, 11 partners specialized in all of law areas, and we have more than 50 lawyers with an outstanding international experience. So we provide legal services in different languages, so Chinese, English, Italian, Spanish, and French. Some of our service areas are corporate law, FDI, tax and accountant, trademark, criminal law, M&A, labor law, working permit, and visa. Please, let's go to the next slide. Okay, so let's start with today's seminar. Please move to the next slide. Thanks. Okay, thank you so much. So the legal structure of a country is outlined by the section of a political season and marked by few milestones. So we can say that the period of 2020 and 2021 is the most significant and symbolic passage in the last few decades for the People's Republics of China. First of all, because it's well known that at the beginning of this year was characterized by the entry force of the foreign investment law that reorganized the foreign investment in China. And second, for the second reason, is that on January 1st, on 2021, will be remembered more vividly for the entry in force of the first Chinese civil code. With this law, the Chinese legislature, for the first time, organized and codified the regulation of civil relation in PRC, defining them principles, rights, and obligation, and regulating the interaction of more than 1 billion of people. So we have to consider that China is continuing to grow. So there are a huge amount of different interests to be balanced when when they draft the civil code. So it can be really difficult. It was really difficult to carry out a detailed codification because organizing the rules of a particular branch of law in a uniform way doesn't necessarily correspond to the needs of an expanding country. So I believe that the legislator was aware that with the code, it would have more stability at the expense of the flexibility. So the legislator always preferred to legislate in a non-homogeneous manner within today. So proceeding step by step and in a certain sectors, following the political agenda and the market demands. So the new code is also a rite of passage. We can consider it as a rite of passage for China because it's a sign of maturity of the legal system and a tool to guide the country's future development. Can we go to the next slide? Thank you. Thank you, Bibi. So the code reflects the usual modus operandi of the Chinese legislator. In fact, in the code, there are articles that are formulated in an open way and with a general scope. In some cases, some articles are just they just have a programmatic function, and it will be necessary to read them with the secondary sources already in force and wait for their implementation with administrative regulation, interpretation, or opinion of the Supreme Court. Can we move to the next slide? Thanks. Thank you. So the code not only represents a milestone for both protection of personal rights and promotion of the rule of law in China, but also reflects the national spirit, as well as is a symbol of the code is a symbol of a glorious age of a nation. So, for example, for the French Civil Code, the Code Napoleon, it represented the legacy of the Napoleonic era. Then the German Civil Code, promulgated in 1896, it was the symbol of a desire of a truly national law that would override the conflicting customs and codes of the German territories. And then another example is the Japanese Code, promulgated in 1898. It was the result of a various movement for modernization. That's why the civil code became a dream in China, and since the Qing dynasty. So on May 28, 2020 of this year, China top legislature, the 13th National People Congress, with more or less 2 months of delay because of the COVID outbreak, passed the final draft of the civil code. And it is the code is the most extensive legislation in the PRC history and is the only one named code. The text is really huge for the Chinese standard and is composed by 1,260 articles and 84 chapters. With the code levels out the gaps of the laws that were promulgated in different historical periods and reviewing them in a unified perspective. Thanks to the code, the legislators solved the shortcomings of the sectoral approach used before. Can we move to the next slide? Thanks. Okay. So the code at the same time introduced new principles and rules aimed to regulate the present issue, such as, for example, the new rules on e-contract that Attorney Chen is going to introduce us later. Moreover, an important step is also taken on individual rights and rights of organization. Two aspects that deserve particular attention are Article 109, which provides the protection of all freedoms, autonomy, and dignity of people, and Article 133, that protect the autonomy of the will of the parties and the principle of self-determination of the subjects. So the code will settle the relationship between individual, community, and society and personal property. So the word code brings an important value because recalls the idea of a norm that wants to order the society and social life in a stable way. In fact, all the changes to the existing legislation are made in the light of the present social, cultural, and political structure. So with all the changes have the goal of a future development of the civil law in China, taking also inspiration from the Indian legal system without renouncing any way at the Chinese characteristics. In this regard, I would like to mention also the Italian Chinese Institute of Wuhan, made by University La Sapienza of Rome, and the Zhongnan University of Economics and Law of Wuhan. This institute issued a master's degree from University La Sapienza in Roma in China. And this master's degree is in European Studies and Private Comparative Law. The head of the institute is the Professor Di Liberto, It's a really famous professor because he, with another professor, Professor Stipani, for the first time they introduced the study of the Roman law in China. Can we move please to the next slide? Thanks. So lawmakers said that the new code incorporate existing law and regulation, modifying and improving them. So the new code will abolish, among other laws, the general principle of civil law amended in 2009, the contract law adopted in 1999, the marriage law amended in 2001, the succession law adopted in 1985, the adoption law amended in 1998, the guarantee law adopted in 1995, the property law adopted in 2007, and the tort law that was adopted in 2009. Can we go to the next slide? Thanks. So let's pass now at the history of the code. Next slide. Thank you so much. So this is not the first time that China tried to adopt a civil code. The first draft was accomplished in 1911 under the Great Qing dynasty with the help of two Japanese scholars, Yoshimasa Matsuoka and Kotaro Shida. The draft was made following the approach of the German civil code, the BGB, and it consisted in 5 parts: general principles, obligation, rights over things, family, and successions. Unfortunately, this draft wasn't promulgated because the dynasty fell in a short time, but the codification in the subsequent decades of years proceed on the basis of this draft. And then in 1930, the Republic of China published a new code. This code had a strong German influence and nowadays is adopted in Taiwan. Anyway, in the mainland, the Communist Party decided to don't use the old age legislation. So China tried again to have a new code in 1954 and in 1962. They tried to issue a new code following the approach of the Union of Soviet Socialist Republic Civil Code, but both failed because of different reasons. After China's reform and opening up in 1978, the codification of the civil law was in the agenda to respond to the demand of a market economy. And then in 1982, a draft of a civil law was made, and this draft was composed by 465 articles, and it was divided in 8 parts: fundamental principles, civil actors, ownership of property, contracts, intellectual property rights, succession of property, civil liabilities, and other regulation. Nevertheless, this draft was never promulgated because in early 1980s, China experienced an immense change. So President Deng Xiaoping and the leading legislator Peng Zhen, they both decided to adopt a step-by-step approach. So China made a separate legislation with the ultimate goal of the adoption of a civil code. So in 1984 was promulgated the law of patent and trademark, and moreover in 1986 the general principles of was promulgated the general principles of law. Can we move to the next slide, please? Okay, thank you. About this law covered many areas such as property, tort liability, contract, marriage, and inheritance. So this laid the groundwork for a civil code. Can we move to the next slide, please? Thank you. So then, after the marriage law, the succession law, and the contract law were promulgated in 1998, so China continued his step-by-step procedure. And in 1998, some legislators and scholars thought that it was the right time to issue a new civil code. So the draft contained 1,209 articles and was published in 2002. But it had many contradictions and it wasn't adopted. Moreover, China continued with the step-by-step procedure. So in 2007 was issued the property law, and in 2009 the tort liability law. So all those regulations continued to follow the economic reforms of China, but they also set firm points and creating fundamental rights for individuals. Then in 2014, the Communist parties called for the progress in the drafting of a unified civil code. Before the final draft, before the draft of the civil code, there were three proposed drafts provided by three different groups of scholars. The first one is Liang Huixing, a leading scholar in the Chinese law academia. He assembled some scholars to codify the civil law rules, and he published his first proposed draft in 2006. Then he had his third revision published in 2013. This draft was composed by 7 parts that are general principles, property rights, principles of obligation, contract, tort liability, family, and successions. Another leading scholar was Wang Liming, the second draft. So the second draft that I want to introduce you is the Wang Liming draft. He published a draft of the civil code in 2005. And the most significant difference with Liang's draft is that Wang suggested that the rights of personality should be in a different part of the code. Anyway, both Liang and Wang have participated in the drafting of national legislation several times before. The last draft, the third one, was provided by Shu Guodong. The draft was named the Green Civil Code due to the reason that the harmony between mankind and nature is more emphasized in this draft of the Civil Code. Anyway, the existence of this draft had a great influence on the final draft of the official Civil Code. Can we move to the next slide? Thank you. Okay, so the code is the result of a long marathon, and the road to the code was opened in 2014 with a necessary step in advancing the country rule of law. So in March 2017, the general provision of the civil code was ratified, and then at the beginning of August 2018, 6 draft parts were reviewed in different sessions of the National People Congress Standing Committee. Then the civil code in its finalized form was presented to and adopted by the National People Congress at its annual session on 28th of May 2020, and concluding then the country's 6-decade journey to enacting a comprehensive and modern civil code. Okay, thank you so much. We can move to the next slide, and I leave the stage to Attorney Chen. Thank you.
Thank you, my colleague. Can you hear me? Thank you, my colleague Nicola. Have a very comprehensive introduction on our civil code, and for my part, I will introduce the main legal issues which was changed in this civil code. Especially, we will focus on the contract part. Next slide, please. So the new civil code, we can see there are 7 parts. In addition to the miscellaneous provision, we will have the general part, property right part, and contract part, and personality rights part, and also the marriage and family part. Next slide, please. Thanks. And tort liability part. This 7 parts is actually, we can also see in the general provisions and principles, which will be abolished on the January 1st of next year. But for regarding our topic today, we will mainly discuss on the influence for the foreign related contract, especially for like foreign parties, joint venture, and some foreign contract matters. So we will introduce the main changes, and we will have some remarks on the like how to avoid the legal risks, and we will provide our basic suggestion on this aspect. Can we have next slide, please? So the first part we will discuss on the contracts and applicable laws. Regarding the civil code, we can see that the civil code still keep that the contracts will still, we can focus on the 3rd paragraph. We can see that regarding the Chinese foreign equity joint venture and contractual joint venture and Chinese foreign cooperation in contract will still apply mandatory apply the PRC laws. And this there will be an interesting things that with the insurance of the foreign investment law, we know that the joint venture law and the foreign contractual joint venture law will be abolished as well. So how to keep the consistency between the wording of the contract and the applicable laws will be also an interesting topic as well. Please move to the next slide. Thank you. So in the civil code, we can see that it lists 19 types of typical contracts, and there are 4 new types contracts. One is the guarantee contract, one is the factoring contract, the 3rd is the property management service contract, and the last one is the partnership contract. These 4 contracts are 4 new typical contract was listed by the civil code. And regarding the guarantee contract, we can see that there has a very big change regarding the general guarantee and the joint and several liability guarantee. Because before, according to the current guarantee law of the PRC, we can know that if the parties did not make an clear consent on the method of and the type of guarantee, such guarantee will be regarded as the joint and several liability guarantee. But now the civil code changed it, like under the circumstance that the parties did not have a clear agreement on the type of guarantee. Such guarantee will be regarded as general guarantee this time. This will lead to an outcome we will discuss later, and we will see the huge difference between these two types of guarantee. Regarding the second part is the factoring contract. Before we don't have such factoring contract, but in practice, we all know when we do business, especially for the global business, we will see that the factoring company is useful for us to solve the cash flow problem, maybe, and solve our financial stress. So with introducing this kind of factoring contract in civil code, it is actually provide a very clear structure to how to manage the practice problem. Because before we don't have this factoring contract, in practice the parties will do the credit transfer or to use the credit transfer rate to achieve this goal. But now we have directly the factoring contract. The companies can introduce the factoring company to solve the financial problem in practice in the future. Regarding the property management service contract, these contracts mainly solve the owners. I would say it improves the owner's rights to manage the community. For instance, it is written that it is forbidden that the service provider cannot cut the electricity or water to push you to pay the service fee. And this is the most obvious clause regarding this contract. Regarding the last contract is the new added contract is the partnership contract. In this contract, it is actually regulate the business mode like the partnership business, which provide basic rules and models to how to draft the contract, like for running the partnership business. From these four new added contract, we can see that actually the civil code make some changes based on our lives and practice. And we will before the civil code, we can see that there are a lot of practical problems cannot be regulated or mentioned by the law. But with the issuance of civil code, we will have a much comprehensive legal structure and rules to manage this kind of issue. So can we move to the next slide? Thank you. In addition to the new added contract, the civil code, according to Article 491, it is said that where the parties concerned conclude a contract in the form of a letter or electronic data to require execution of a letter of confirmation, the contract shall be concluded at the time of execution of the letter of confirmation, which means that the civil code actually confirmed the form of the e-contracts. For instance, many companies signing contracts actually using the PO instead of contracts, and with exchanging the emails as well to confirm their contractual relationship. But with this article, we can see that when the companies exchanging the PO or order confirmation, we will see that this article, the mentioned article 491 of the Civil Code, has clearly mentioned that if your PO mentioned that the effective date of the contract will be the signature of the order confirmation, then you need to be cautious about the signature of the order confirmation as well. But anyway, the purpose of setting this, confirming these e-contract forms, I guess, is because there are a lot of online shopping nowadays. So this part of provisions also actually trying to regulate the online shopping dispute. The contractual dispute originate from the online shopping. For instance, if one party's products or service has been released through the internet, an e-contract will be formed once the other party selects the products and service and submit the order successfully. When you submit the order in the online platform like Taobao or Jingdong, when you at the time you submit the order, it will be regarded as the acceptance, and the contract will be established at that time. So we move to the next slide. Thank you. So as we can see, the conclusion and effectiveness of contract can have different forms and depends on the specific case. So because of this point, I will remind the company to pay attention to the aspect of how to keep evidence for confirming the contractual relationship with your business partner, especially for the foreign related contracts. When in some cases we can see that even though we use the PO, we just exchange the PO without company chop. But in legal practice, when we proceeding the court procedures, the judge will ask us to provide not just the text of the PO, but as well the email exchange records. So when we exchange the PO, like we using an email to place an order or to confirm the order, we have to keep that email records, and we will try. Your company need to try the best to keep to try to make the counterparts stamp on the PO with their company chop. And if you have such clause of your PO saying that the order confirmation is needed, then you have to send another order confirmation for asking their endorsement as well. So this is the legal risk from this aspect, and we can cover this risk with keeping, like placing a very comprehensive PO with very with many legal provisions, and sending and very beautiful order confirmation to cover our risk and make sure the existence of the contractual relationship will be much better for us to avoid the substantial potential disputes in the future. So we move to the next slide. Thank you. So as I mentioned before, the main changes of civil code is the guarantee contract. And regarding the main changes, as you can see, the Article 686, the blue part, which states that where the parties do not stipulate the type of guarantee or where the agreement is not clear, the guarantee responsibility shall be assumed in accordance with the general guarantee instead of the joint and several liability, joint and several guarantee as well before. So, which means that the general guarantee could enjoy the defense where the creditor has to go after the debtor first. And with the normally we will discuss the difference between the general guarantee and the joint and several guarantee. But the problem is that the main difference, I would say, is that the benefits of discussion. So after this change, we will see that the risk of the guarantor will be more less if the agreement of is not clear on whether the type of the guarantee. So after the civil code become effective, such guarantee will be regarded as a general guarantee, meaning that the creditor may only claim for debt payment with the guarantor after it claims with the debtor, and it solves the remedies by the debtor. That would be much more fair and for the guarantor as well. So you can see the transfer of mortgage property is subject to the prior consent by the creditor under the current guarantee law. But under the civil code, you can see that unless otherwise agreed by the parties, the mortgage property can be transferred with a prior notice by the creditor. The ownership transfer of the mortgage asset will not impact the creditor's mortgage rights over the mortgage assets. So you can see there is also a minor change here regarding the transfer of the mortgage property. And this change means that before we cannot transfer such property without the consent of the creditor, but now with the insurance of civil code, we can also transfer the mortgage property to get back the money, because this change is mainly to avoid I would say to avoid the deadlock phenomenon in legal practice, because if without the consent of the creditor, we cannot transfer the property, even though the transfer of the property is maybe helpful to solve the problem. But if the creditor did not agree, we can do nothing. So this is not reasonable. So this change will be also helpful for the future practice on the mortgage property aspect. And we can keep an eye on this aspect as well. So let's move to the next slide. Thanks. We can move to the next slide. Yeah. So in addition to the guarantee issue, we can note the previous one. Let's go back to the previous slide. Why the? Yeah, next slide. Next slide. We can move to the next slide. Why the slide is not that? We need to find the next slide after the guarantee issue. Maybe it's the previous one. Previous one.
Maybe I will switch the PowerPoint that you sent me like 2 minutes just before the webinar.
It will be okay, I guess.
This one?
I can't see your screen.
Sorry.
It's the one, the title is the fairness and good faith.
This one?
Yes, this one. Yes, thank you. Thank you so much. So, again,
is this the slide?
Also make some of the principles of fairness and good faith, on which we can see that, like for instance, according to the Article 496, is regarding the standard clauses. Before the standard clauses, we can see that it will be okay. It will be before the standard clauses will not exempt, like it will be only exempt when you create some extra burdens on the counterparts, or you make some very unfair clause and you didn't remind the counterpart to notice on that. But according to the newest change regarding the standard clauses, we can see that the civil code put more exemption clause, like if the guests of the hotel did not notice the unfair clause of the standard contract, we can have more reasons to argue and make defense on the effectiveness of the standard contract. So we can, on the other hand, we can see that the Civil Code also increased the protection to the creditors by improving the relevant provisions of the loan contracts and as well as the financial lease contract. And there is also a special chapter on providing the guarantee contracts. Those changes is actually making the parties making the provisions more reasonable to proceed in practice based on the principle of fairness and good faith. And as we can see that later we will also mention the change of circumstance principle. I would say that the change of circumstance principle is also the perspective from the initial intention to making these changes, including the principle of change of circumstance based on the situation of the COVID-19. We would say I would say that it's also they will also have a basic based on the fairness and good faith, which makes the parties can have a more fair situation to proceed to the performance of the contract. So we can move to the next slide. Next slide, please. Okay. So also regarding the termination of the contracts, we can just because before based on the current regulations, we can see that the termination is the previous one. Oh, it will be okay. It will be okay if you keep this one. You can see that regarding the termination of the contract, it's the previous 2 slides or 3 slides, I guess. Yeah, this one. The termination of contracts. Regarding the termination of contracts, the main changes I would remind everyone is the Civil Code allow termination of the contract with a unfixed contractual term at any time without cause. So regarding the unfixed contractual term, we will see that if we didn't provide a right to unilateral terminate the contract at any time, the parties will be suffered like forever. So this time the Civil Code give this I would say a very reasonable change on the grant this right to the parties under the unfixed contractual term. So next slide, please. Okay, so we can also see that the Civil Code allow the termination right of with the unfixed contractual term and any time without cause. And based on our current contract laws or related regulation, we can see that the termination of contract can be mainly divided into 2 parts. One is the statutory termination. The second one is the agreed termination. We can move to the next slide. We will say that this time the Civil Code also keep this two-part termination method. But the main changes I would say that first of all is the one I mentioned just before, is the termination right of the under the unfixed contractual term contract. And the second one is this time the Civil Code divided the liability for breach of contract and the termination of contract. Because before in legal practice, there will be a very arguable legal issue like some people saying that the claiming the liability for breach of contract, you need to keep the existence, the effectiveness of the contract. In other words, they think that without the effectiveness of the contract, if the contract is already terminated, then some people will say that if the contract is terminated, then you have no right to claim for the breach of liability. Because so this time the Civil Code make a very clear statement on this kind of issue. Civil Code saying that the termination of contract and the liability for breach of contract can be coexistent at the same time. So this will avoid some controversial issue in legal practice as well. And after that, we can see the change of circumstance, which I mentioned before. During the epidemic, due to the epidemic situation of the COVID-19, we can see that the Civil Code has clarified the principle of change of circumstance. So before, we don't have the written rules regarding the change of circumstance. So after, according to the Article 533 of the Civil Code, we can see that it is clearly mentioned in the Civil Code that the parties can use this principle of change of circumstance. We can do a fully negotiation first before proceeding the legal actions. We can, after, if we cannot reach a consent on the dispute resolution, we will say that we can sue the counterpart, or we go to arbitration to ask for the adjustment or the termination of the contract based on the actual situation, which will be decided by the arbitrator or the judge. So this principle provides a very useful tool for us to adjusting the situation of the performance of contract based on the actual situation, the unexpected situation. Before this, the issuance of Civil Code, this principle is actually mentioned by the interpretation tool of PRC Contract Law, but now they already put it into the Civil Code, which is like consistent with the principle. So I would say this is also a big changes in the Civil Code. So let's move to the next slide. So regarding the force majeure, we also saying that it can be coexistent with the principle of the change of circumstance. So in case we cannot fulfill the situation of applying the force majeure principle, we can consider the application of the principle of change of circumstance to adjust the contract performance situation as we need. Next slide, please. So after the brief introduction on the main changes of Civil Code, we will say that there are some main changes related to the, especially is useful for the foreign related contract. In addition to the things I mentioned before, the Civil Code also mentioned there are some other points like the termination time of the, like for instance, the termination time of the contract. The Civil Code grants the parties the rights to sue using the arbitration or using the litigation to terminate the contract. And the termination time of the contract will be the time the time the counterpart receive your statement of claim and maybe the application letter of arbitration. as well. So this is some minor changes as well. And also, there are also a very important part is the preliminary contract, which is also mentioned by the confirmed. I would say the effectiveness of this pre-contract is confirmed by the civil code as well. So in practice, when we run the business, we run a new project. Normally we sign like a document like a LOI, letter of intent. So regarding this kind of LOI, we will call them a pre-contract. So we can pay more attention on we can also have because the civil code provides the right that the party can also claim the liability for breach of contract based on the LOI or some other kinds of the pre-contract. So when drafting the LOI, we will suggest it to be careful, pay attention on the input of the clause of breach of contract. The liability, if we clarify the liability of breach of contract, that would be more useful and more reasonable for us before we starting the project. And this is one other legal risks we can be careful as well. So this part I will give some practical insights based on our introduction, because during the cases we handled, we conclude some we will say it's some basic experience and tips for you to avoiding the legal risks. Next slide, please. Next slide, please. Okay. So the first one is to check the parties of the contract. We need to check many times if the counterpart is. You need to confirm the counterpart is the right counterpart. The parties you need to cooperate or doing business with. Some company will tend to use their Hong Kong company, or some affiliate company abroad to sign the contract. But normally we would suggest that because if they use such affiliate company and using some other companies, which will cause a very huge problem when you proceeding legal actions like litigations, and which it will involve the jurisdiction issue and the applicable law issue as well. And in addition to the parties, I would say that we can also focus on the CHOP. This is the cases we handled before, because many clients ask us because some counterparts during the email exchanges, they CHOP on the order confirmation with using their contract CHOP. Like contract CHOP, they have many CHOPs of the company. You need to confirm that they're using their official CHOP for the order confirmation or the signature of the contract or PO, because even though we may be able to prove in legal practice to prove the other CHOP is also belongs to this company as well, but this will cause unnecessary trouble for us to prove this issue during the litigation. So you need to check the CHOP, and you need to check the counterpart, the identity of the counterpart, and normally we will also suggest the parties CHOP on every page of the contract, and check the English of the Chinese language say the same thing. Actually, the civil code has mentioned that if there is any discrepancy between the different language, they will tend to interpret it based on the principle of fairness, or maybe some like the principle we mentioned before. Like they will interpret it. We will explain this cause discrepancy in a very reasonable way, maybe. So in order to avoid such trouble and unnecessary discrepancy, we are saying that first, you can agree in the contract that which language shall prevail, or we need to confirm both languages are saying the same thing. So we can move to the next slide. Regarding the quality standard, because in many product quality cases, we miss so many similar situations that when we try to proceed the legal actions to sue the counterparts, we will see that we also, our client also claiming that they cannot meet the quality standard as they want, like maybe the sample products they provided is not consistent with the product they give us at the end. So we need to set a clear quality standard, especially like buying the mask and the computer, shoes, and anything else. Set a clear quality standard. I mean, it's from the professional perspective to set the quality standard and attach to the maybe the purchase contract, and that would be more comprehensive to cover the legal risks for us. Let's move to the next slide. Thank you. Next slide. Next. Yeah. So the third one is we would suggest you to do a quality control in China before the shipment, because when we the previous one, yes, because it will be okay if we keep okay this one, because we miss some situations that inspection of the products on in foreign countries. It is possible that the inspection in the foreign countries may not be recognized by the court in China, and those official reports or like inspection report will cause many of works. Maybe when you try to using this kind of foreign inspection, you need to do the notarization procedure and blah blah blah, which will cause unnecessary trouble for us. So we would suggest that you checking the goods before the shipment is the only safe way to sure that in case of dispute, you could take the legal action to sue the counterparts. So next slide, please. Also, as I mentioned before, including in the pre-contract like LOI and the purchase contract, we will strongly suggest that we set a liquidated damage cost and make it clear how much the counterpart will pay in case of violation. However, you don't need to put a nonsense amount. You can put a reasonable amount to find a balance during the negotiation with the counterpart, which will provide a very strong, I would say, a method for us to take legal actions and claim compensation based on this provision. Otherwise, we can only claim the actual loss we suffer. But this means nothing, because we cannot get. Normally, the loss can be much bigger than we expect.